co-judge is also ready. If my co-judge is also ready, then we can.
Hello, good morning.
Come on.
So, shall we start?
Yes, sir. Good morning, everyone. It is our esteemed privilege to have with us our judges for quarterfinals. For the attention of the judges, we have here team code 129, composed of speaker 1, speaker 2, researcher, representing the petitioner, and team code 119, representing the respondents, speaker 1, speaker 2, and the researchers. I hope the teams are familiar with the rules. Both teams have 45 minutes each for their representation. Teams, please convey your time required for each speaker. You can either put it in the chat box or you can unmute and tell your time apportionment. Team 109 and 119, please convey your time apportionment.
Let's just speak something. Everybody, I want
Good morning.
Team 109, your voice is not clear. Please convey the time apportionment through the chat.
Yeah.
Without interruption of the session, teams, please specify the time apportionment.
Hello, Session Server. Hello, can you hear me? Am I audible?
Yes, yes.
So the total time is 45 minutes per team, right? If yes, then the first speaker will have 20 minutes. Second speaker will also have 20 minutes, and we will leave 5 minutes for rebuttal.
And team 109, what is your time division between the speakers?
Good morning.
Good morning.
My name is Amuda Kolawale Ibrahim, and can you hear me?
Yes, I can hear you.
All right. I am the first speaker, and I'll be talking for 25 minutes, while the second speaker would argue for 15 minutes and will leave 5 minutes for rebuttals.
Okay. Thank you. Team 109, speaker 1, you have 20 minutes, and speaker 2, you have also 20 minutes, and your team will have 5 minutes for the rebuttal. There will be a warning given for half time, 5 minutes, 3 minutes, 1 minute, which is left for you, and then time over in the chat box. Please ensure that you monitor the chat box correctly. You may also continue to speak with the permission of the group. If the lordships are ready, I would like to invite the first speaker of the petitioner to speak. Team 109, speaker 1, your time starts now.
May it please this honorable court, I am Amuda Kolawole Ibrahim, and appearing with me is my co-counsel, Fabumi Boluwatito. Together, we announce our appearance as counsel for the petitioner in this case. Your Lordship, the case before this honorable court is between Octa Limited, afterwards referred to as the petitioner, and owners and parties interested in the MV Moonlight vessel, afterwards referred to as the respondent. May it please this honorable court to benefit from summary of fact of this case.
Yes, please.
Most graceful, Your Lordship. Your Lordship, the petitioner entered into an agreement with the respondent seagoing vessel from the Kingdom of AEU to the west coast of Indo. The goods were supposed to arrive at the west coast of Indo on the 11th of July, 2021. However, on the 10th of July, the respondent informed the petitioner that he has jettisoned 500 to 600 empty cargo of methanol. And on the 11th of July, when the goods got to the west coast of Indo, the petitioner realized that it was actually 650 empty cargo of methanol that was missing. And this prompted the petitioner to secure arrest of vessel. After the vessel was released, the respondent, having possessive lien over the cargo, refused to release the cargo and demanded that the petitioner pay the general average as determined by the average adjusters. We're in court today, Your Lordship, because the petitioner contends that the general average is legally unsustainable due to the fact that the ship was in fact unseaworthy. Counsel seeks the leave of the court to proceed.
Yes, ma'am. Please proceed.
Yeah. Most grateful, Your Lordship. Flowing from the facts of this case, 5 issues were raised for determination, and I will be arguing the merits of the first, second, and third issue, while my co-counsel will argue the merits of the 4th and the 5th issue. Counsel seeks this leave of the court to proceed.
Please proceed.
Commencing with the first issue, Your Lordship, as to whether the exercise of admiralty jurisdiction by the court is valid, the petitioner answers in the affirmative, and that this court has competence and can adjudicate on this matter before it. And our position is premised on Section 9 of the 2015 Amendment to the Arbitration and Conciliation Act 1996, which empowers this court to preside over international commercial arbitration seated outside India. Furthermore, jurisdiction, my lord, Article 2, subsection 3 on the International Convention on Arrest of Ships 1999 provides, and I read before this. Article 2, subsection 3 on the International Convention on the Arrest of Ships 1999 provides, and I read, that a ship may be arrested for the purpose of obtaining security, notwithstanding that, by virtue of a jurisdiction clause or arbitration clause in any relevant document or otherwise, the maritime claim in respect of which the arrest is effected is to be adjudicated in a state other than the state where the arrest is effected, or is to be arbitrated, or is to be adjudicated subject to the laws of another state. Your Lordship, Article 11 on the Convention relating to the arrest of seagoing vessels 1952 provides that a ship may only be arrested under the authority of a court or of the appropriate judicial authority of the contracting state in which the arrest is made. Your Lordship, Section 3 of the Admiralty Jurisdiction and Settlement of Maritime Claim Act 2017, which is binding on this court, provides that subject to the provisions of Section 4 and 5, the jurisdiction in respect of all maritime claims under this act shall vest in the respective high courts and be exercisable over the waters up to and including the territorial waters of their respective jurisdiction in accordance with the provisions contained in the act. Your Lordship, Section 4 of this said Admiralty Jurisdiction and Settlement of Maritime Claims Act provide for the jurisdiction of high courts in respect to maritime claim, and this case before this honorable court today falls within the jurisdiction of this court. Furthermore, Your Lordship, in the statement of facts, there were issues of fraud as to the inconsistencies between the amount of cargo said by the respondent, that is 500 to 600 MT that was said to be jettisoned, and the exact amount realized after a survey was taken by the petitioner. And in the Supreme Court case of Radhakrishna versus Mastro Engineers, the court held that issues of arbitration, Your Lordship, are not arbitrable. Thus, if this case is allowed to go before an arbitral tribunal, Your Lordship, we would find the situation where we'll be referring to the provisions of Section 9, subsection 3 of the Arbitration and Conciliation Act 1996, which provides that even after an arbitral tribunal has been constituted, where the court finds that circumstances exist which may not render the remedy provided under Section 17 efficacious, it has the jurisdiction to adjudicate on the matter in the interest of justice. Your Lordship, in the respondents argued in their brief of argument, particularly paragraph 2.3 of page 13, that, permit me, Your Lordship, particularly paragraph 2.3 of page 13, that this court lacks jurisdiction to sit on this matter because the goods that were jettisoned outside the waters of India. However, Your Lordship, the case cited by the respondent, that is Latore versus Union of India, it's fundamentally different from the case before this honorable court because one, it was a criminal case, and two, it was stated expressly in the statement of fact that the vessel was off the coast of Kerala at that time. And in the statement of fact of this instant case, Your Lordship, it was never stated, nor was it said that the vessel was outside the waters of India. So to argue that the goods were jettisoned outside the waters of India is bringing new facts into the agreed fact, which was not there in the first place. Thus, the petitioner humbly submits that this court has jurisdiction and is competent to adjudicate on this matter before it, Your Lordship. Proceeding to my second issue.
Counsel, just a second before you proceed.
Okay.
Elaborate for us, how exactly do you say there is jurisdiction if this incident did not happen within the territorial jurisdiction of the maritime waters?
I did not get a question, Your Lordship.
How can you bring this within our jurisdiction? How can you bring this within our jurisdiction if you also contend? Can you hear me?
I can now, Your Lordship.
Yes. So how do you contend that this case can come before our jurisdiction if you also contend that this did not happen within the territorial waters?
Your Lordship, I
elaborate on the Admiralty Jurisdiction Council. How exactly can we exercise Admiralty jurisdiction? On what territories?
I can't actually hear.
On what territories? There's got to be a certain territory within which a court can exercise Admiralty jurisdiction. Am I right?
Yes. Yes, you are.
Elaborate for us what territories those are.
Your Lordship, this court, that is the Court of Indo, can exercise jurisdiction over this matter if it is within its territorial water. Your Lordship, the vessel in question, that is the Moonlight vessel, is actually in the territorial waters of Indo presently, Your Lordship, and the arrest was made within the territorial waters of Indo as per the agreed statement of fact, Your Lordship. Thus, it puts this case within the jurisdiction of this honorable court, Your Lordship.
Okay. Section 9 of the Arbitration Act that you have relied on, it talks about interim orders, right? Section 9 also goes on to further state that apart from interim orders, all the other factual disputes will have to be determined by the arbitral forum. If that is the case, only an interim order can be granted by this court. Should the matter not go back to the proper arbitration forum?
Can Your Lordship repeat the question?
Section 9 of the Arbitration Act that you have relied on talks about interim orders passed by the Court of Competent Jurisdiction, right? If an interim order is all you are seeking, we have already granted an interim order The interim order was also considered by the court. Once that matter is complete, it has to go back to the proper arbitral forum. Section 9 specifically states so. If that is the case, how do we continue to exercise jurisdiction? Shouldn't it go back to the arbitration?
Your Lordship, Section 4 of the Admiralty Jurisdiction and Settlement of Maritime Claims Act, it listed a number of things that this court and high courts in India can actually adjudicate upon as regards to maritime claim. And one of this, permit me, Your Lordship, to open the said. Yes, Your Lordship, and one of this is Section 4 of the Admiralty Jurisdiction Assessment of Maritime Claim Act provides, and I read that the High Court may exercise jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of a dispute regarding the possession or ownership of a vessel or the ownership of any share therein, dispute between co-owners, mortgage or a charge of same, loss or damage caused by the operation of a vessel, loss or damage to or in connection to any goods. That places the jurisdiction of this case within this court, Your Lordship.
Okay, last question, counsel. Do you have any authority to state that when there is a, let's say, an opposing arbitration clause, you've got two statutes, you're competing with the Admiralty Act and you're going against the Arbitration Act, right? If that is the case, do you have any authority to state that the Admiralty Act has supersedence over the Arbitration Act? Because arbitration is a special statute. And by the principles of law, special statute always has priority. How do you say that the Admiralty Act is the one that has to apply, not the Arbitration Act?
Oh,
Do you have any authority for that? Do you have a
No, Your
precedence
Lordship.
you can rely on?
No, Your Lordship.
Proceed, please proceed.
Regarding the second issue, Your Lordship, as to whether the declaration of general average is legally sustainable if the vessel is unseaworthy, the petitioner answers in the negative that the declaration of general average is not legally sustainable as the losses that occurred were as a result of the unseaworthiness of the respondent vessel. Our position on the NYPE 2015 Time Charter, particularly clause 33 subsection C, which provides that the owners of a ship are entitled to receive general average, even if they fail to exercise due diligence to make their ship seaworthy, provided that the casualty giving rise to a claim in general average was not caused by the unseaworthiness, Your Lordship. But in this instance case, the loss that occasioned the claim of general average was as the result of the unseaworthiness, Your Lordship, and the respondents cannot be entitled to contributions in general average. Your Lordship, bad weather, which was stated in line 33 of the agreed statement of fact, has been the direct cause of the loss incurred by the cargo owners, is a usual occurrence in sea voyages, Your Lordship, and a ship which is seaworthy must be prepared to withstand such an occurrence, Your Lordship. The fact that the respondent vessel failed to withstand this bad weather points to the fact that it is in fact unseaworthy. Thus, Your Lordship, this unseaworthiness of the respondent vessel is the direct cause of the loss of cargo and nothing else. Your Lordship, the respondents have argued that in their brief of argument, particularly paragraph 2.4 in page 15, that the defective passage plan played a part in the unseaworthiness of the vessel. We are glad that the respondents agreed that their vessel was unseaworthy. But however, Your Lordship, in the statement of facts, there was nothing pointing to the fact that it was the defective passage, passage plan that led to the unseaworthiness. What was stated in the agreed statement of fact, Your Lordship, was the fact that bad weather, Your Lordship, bad weather led to the loss of cargo, your lordship, and the incapacity of the respondent ship to withstand bad weather, which is a usual occurrence in sea voyages, is the actual cause of the loss of cargo, your lordship, not the defective passage plan. Thus, the petitioner humbly submits that the respondents are not entitled to a claim in general average because the unseaworthiness caused the loss of damage and not an act of the petitioner, your lordship.
Okay, a further clarification, counsel. When does the ship have to be seaworthy? At what point of time of the voyage is the ship expected to be seaworthy?
Before it commences on the voyage, your lordship.
Exactly. Is there any statute or authority which tells you that the ship has to be seaworthy throughout the entire voyage?
No, your lordship.
Can such an assurance be made?
I did not get your question.
Can such an assurance be made by the owner of the ship that the ship would be seaworthy throughout the entire voyage?
Yes, that is the reason why the petitioner actually contracted the respondent, because there was an assurance that the ship would actually deliver the goods from the kingdom of AEU to the west coast of Indo, your lordship.
I'm asking you, is there such a presumption in law that the ship will be seaworthy throughout the entire course of the voyage? Can you make such a presumption in law? Forget about the facts. I'm asking you, in law, is it possible? Do you have any authority for that? Seaworthiness throughout the entire voyage? If that is the case, and if
the egg rules, your lordship.
Pardon? I didn't get you.
The egg rules, your lordship.
Egg rules.
Okay. Right. Just one more question. Are you aware of the principle of remoteness of damage?
The principle of remoteness of damage.
Exactly. Remoteness of damage. The facts specifically talk about bad weather, right? And if you're saying the bad weather was a contributory cause, and if the ship became unseaworthy at some point of time in the voyage, due to the, let's say, the specific path that it had to take, even through unsafe ports, if at all it became unseaworthy because of that, how do you say that the ship owner is still liable? As a claimant, you had to make sure that there was seaworthiness at the commencement. The ship owner had to warrant that, granted. During the course, it may have become unseaworthy, specifically due to bad weather. And as you argued, very well argued, I can accept bad sea weather is not an exception. Bad sea weather is something the ship has to consider. But bad sea weather has been a contributory cause in several cases of unseaworthiness of ship, leading to a number of incidents. So a direct causation, can you draw a direct causation between the unseaworthiness and the damage that you have sustained? Or is the direct causation the bad weather? If the bad weather is the direct cause, unseaworthiness is only contributing to it. It is not the end result. So by the principles of remoteness of damage, you cannot make the owner of the ship liable.
Your lordship, we are arguing that if the vessel was in the first place seaworthy, regardless of like I said earlier, your lordship, there was nothing pointing to the fact that it actually became seaworthy by passing a place that was actually unsafe. And if it became unseaworthy at that time, the respondent had a duty to actually communicate to the petitioner, but it did not. He only communicated after it had jettisoned goods into the sea. It could have actually stopped the voyage, but it did not. In this case, the unseaworthiness, your lordship, was actually the cause of the damage. If the ship was seaworthy, it should have been able to withstand the bad weather that occasioned at sea, your lordship. The statement of fact never said it was a tempest, nor did they call it a storm. It specifically said bad weather, your lordship.
Yes. Proceed.
Most grateful, your lordship. Lordship, with regards to the third issue, as to whether the court considering the issue is bound by sanction imposed by a third country, the petitioner answers in the negative, that this court is not bound by sanction imposed by a third country. And our first argument hints on one of the pillars of international maritime law, that is sovereignty. Your lordship, of in any state of the world, one feature of a state is sovereignty. And a third state cannot impose on another a law or sanction that she has not imposed on herself, your lordship. Your lordship, in the case of Pradeep KN versus the station house officer, the singular judge held that an arbitrary tribunal cannot pass an order to enforce its own order. That is, if this case goes to arbitration, my lord, if it goes before an arbitrary tribunal, it will still have to come back before an honorable court, before this honorable court, before the arbitral awards will be enforced, your lordship. And under section 48 to subsection 2A and section 57 subsection 1B of the Indian Arbitration Act, the court, this honorable court, can still refuse the enforcement of an arbitral award granted by a foreign seated arbitration if the subject matter of this dispute is not capable of being settled by arbitration. Your lordship, we pointed to this honorable court today that there are cases of fraud in question here, loss of cargo in question here. Thus, this court, your lordship, is not bound by sanction imposed by a third country. The petitioner humbly submits, your lordship, that this court is not bound by sanction imposed by a third country.
Can you please elaborate on the principle of fraud, counsel? I don't understand how fraud plays a role here. I understand that you say that initially there was only 500 to 600 million tons that were jettisoned, and all of a sudden there were 650 tons that were recorded. But how exactly does that come to fraud? Because when you allege fraud, the burden is on you to prove fraud. You can't merely make such allegations. Please convince us of fraud. If there is no fraud, we can go back to arbitration as well.
Your lordship, the respondent informed us that 500 to 600 was actually jettisoned into the sea. 500 to 600, meaning it could be 590, your lordship. It could be 599. It could actually be 600, your lordship. But in this instance case, after we took a survey, we realized that it was 650, your lordship. Immediately, your lordship, as a reasonable man, your lordship, the first thing that comes into question is, where did the remaining 50 empty cargo of methanol go to, your lordship? It brings the question that, okay, it might be due to theft, your lordship. It might be due to, okay, the respondent wanting to keep a part of this cargo for himself and not informing this honorable, and not wanting the petitioner to know this, your lordship. Thus,
Counsel, just a moment, counsel. Give us law, counsel. Give us law. Let's not go on to hypotheticals. Give us a law. Give us principles of law. Give us a section. Give us a statute. Give us a maxim that we can rely on to state that there was fraud, that the act of the owner of the ship, that the act of the let's say the crew of the ship was not appropriate, that there was probably fraud. Was there a duty on the cargo, duty on the crew members, duty on the owner of the ship? Give us law.
Your lordship, the New York Antwerp rules, your lordship, rule paramount of the New York Antwerp rules, your lordship, it provides for the allowance of only reasonable sacrifices and expenditure, your lordship. What is reasonable? The only part of a sacrifice that is reasonable. In this instance case, your lordship, the sacrifice made by the respondent is unreasonable, your lordship.
So are you saying there was no need for 650 MT to be jettisoned?
Yes, your lordship.
Counsel, then again, you're not talking about fraud. More importantly, when there is a disaster happening on the ship, I believe the captain of the ship and the crew will be at liberty to decide the quantity of cargo that has to be jettisoned for the safety of the ship. And more importantly, when such an incident is happening, I don't believe that the crew or the captain of the ship would be in a position to give you an exact quantifiable amount to the limit, an exact amount of the cargo that was jettisoned.
It can be only ascertained after a survey. Right?
Exactly. There's got to be some reasonable liberty. There is some liberty. There is some reasonable room that is given to the crew members and to the captain. You can't expect them to give you an exact amount immediately when the disaster has happened, because that happens after the survey. That happens once the ship is all come to the port. So fraud, we are not convinced also.
Your lordship, most disrespectful your lordship, like you said, it is impossible to give an exact number in this situation, your lordship. That is why the respondent in this instant case did not come before this honorable court and say the vessel jettisoned 515 empty cargo. It did not say 520. He put it between a range between 500 to 600, your lordship. And in this instant case, after the survey was taken, your lordship, before the survey would have been taken, the respondent informed the petitioner, your lordship, that 500 to 600 was actually jettisoned. And after the survey was taken, it was 650 that was realized. I understand the fact that during these situations, it is impossible to know the exact number, but the respondent still gave us a range, your lordship. And after the survey was taken, what was realized goes beyond the range given by the respondent, your lordship.
Okay, regarding your third issue, so the insurance company, by the letter of subrogation, they got the letter of subrogation from you. So they are a company included in the SDN list. So what is the relevance of that here? They are a sanctioned company. So does it come under this court's jurisdiction?
Let's go through your lordship. Your lordship, regarding the insurance company being listed under the SDL list, the case of Vidyadrolia, that is Vidyadrolia versus Droga Trading Corporation's 2021-2 SCC1, provides that in this case, third-party rights do not apply. In this instant case, third-party rights do not apply. The insurance company in this instant case is a third party, and the fact that it is under the NDN list means the respondent should not actually be contracting with such person, because those people under the NDN list are SDN means specially designated nationals. They are people blocked and people that people should not actually deal with. People should not enter an agreement with. So it is not actually binding your lordship.
Anyway, your time is over, I think.
Yes, I would defer positions to my co-counsel to argue the merits of the fourth and fifth issue, your lordship.
Yes.
Once again, your lordship, my name is Fabumi Boluatito. I will be arguing the merit of the fourth and the fifth issue. Whether counsel seeks the leave of the court to proceed. Whether the court can adjudicate on the rival claims considering the fact that the alleged damage occurred within a territorial water. Your lordship, the petitioner answers in the affirmative. It is important to note that your honorable court has the power to adjudicate on the rival claims resting on the foregoing principles and arguments. Firstly, the provision of section 2, subsection 1 and 2 of the Arbitration Act of 1969 has enabled the parties to an international commercial arbitration outside India to approach the Indian court to seek interim relief. Also, section 1 of the International Convention relating to diverse seagoing ships, a convention ratified by India, also provide for the grant of these maritime claims within the spectrum of the convention. Your lordship, also, Article 1 of the International Convention on Arrest of Ships, 1999, also has listed in its provision the grant of the maritime claim prayed for by the parties to the dispute. Your lordship, in the fact of the case, specifically line 39 to 44, there is a claim for the short delivery and the demanding of the general average contribution. Your lordship, it can be seen that pursuant to the above provisions mentioned in section 2 and section 1 of the Arbitration Act of 1969, the court can adjudicate on the rival claim. Your Lordship, the petitioner hereby submits that the pursuant to the above provisions, this honorable court can adjudicate on the rival claims.
Based on the arrest convention?
Yeah, I can't hear you.
Was it
The
based on the arrest convention, or are you specifically making any point from the statute, Indian statute?
Yes, I'm making point from the statute. Also, the maritime claims which the parties seek are within the jurisdiction of this court to grant as provided in Section 4 of the Admiralty Act of 2017, Your Lordship.
Counsel, just a moment. Can you elaborate on the arrest of sea vessels convention? Please tell us what arrest is the arrest of sea vessels convention. Enlighten us on what exactly the convention is made for. Does the present, can you cover the present circumstance under the convention?
Your Lordship, the arrest of sea convention under Section 2, under Section 2 of the convention, it can be seen clearly that the rival claims considered and brought before this court can be adjudicated within the jurisdiction of this court, and the demanding of the general average contribution can be occurred because the damage occurred within these territorial waters.
Counsel, just a moment. Give us the object or the purpose of the convention. What is the purpose of the convention? Why has it been created? Purpose, the object of the convention.
Your Lordship,
considering the object of the convention, does the present case come under the convention? Does it have any application whatsoever?
Your Lordship, a case Your Lordship, I shall defer proceedings to my leading counsel.
Let's complete
Thank
your
you,
argument
Lordship.
first. Wait, let's just complete your argument first. Speaker 2, let's complete your argument and then we'll go to the question.
Your Lordship, counsel seeks to lead the court to proceed to the final issue, Your Lordship.
Yes.
The fifth issue. Thank you, Your Lordship. Whether the provision of the Arbitration Act exclude an action in rem from its purview as non-arbitrable. Your Lordship, it is important to know that there is no provision in the Arbitration and Conciliation Act that exclude an action in rem from its purview as non-arbitrable. The landmark case of this issue is in the Booz Allen case. The Booz Allen case and Hamilton versus SBI Home Finance Limited of 2011. Your Lordship, this case shed more light on the non-arbitral nature of an action in rem, where it held that the enforcement of rights in rem are unsuited for arbitration and can only be adjudicated by courts on public tribunals. Your Lordship, according to the court, an action in rem has an ego omnis. An ego omnis is a Latin word which means towards all or towards everyone. It has an effect and are directed against a property, determining the rights of the parties, exercisable against the public at large. For the purpose of knowledge of this court, I would love to give a succinct definition of an action in rem. An action in rem is a proprietary action brought against the object that is the subject of a dispute. Your Lordship, the determined rights adjudicated as a result of an action in rem are conclusive against the whole world rather than against a personal person. Your Lordship, in Vidiadrolia case, which is going to be a case study here, Your Lordship, versus Dogger Trading Corporation of 2021, the court propounded a four-fold test for determining when a dispute is non-arbitrable. Your Lordship, would you please this court for me to mention the 4 elements of the test? Thank you, Your Lordship. The four elements of the test are, firstly, when the cause of an action and the subject matter of the dispute relates to an action in rem that do not pertain to subordinate rights in personam that arise from right in rem. That's the first test. Secondly, when the cause of an action and the subject matter of the dispute affects the third party rights, have ego omnis effect. Ego omnis, as mentioned earlier, is a Latin phrase which means towards all or towards everyone. And is related to right in rem. And it requires centralized adjudication and hence mutual adjudication, which will be enforceable. My Lord, when the cause of an action and the subject matter of the dispute relate to inalienable sovereign and public interest functions of the state, Your Lordship, mutual adjudication would be unenforceable. Lastly, Your Lord, the fourth test, when the subject matter of the dispute is expressly or by necessary implication non-arbitrable as per mandatory statutes. From the foregoing, it can be deduced that the ratiocinations of the court in first and the second element of the test apply to this instant case. For the purpose of emphasis, I would like to mention the first and the second element. Firstly, when the cause of an action and the subject matter of the discipline relates to an action in rem that do not pertain to subordinate rights in personam that arise from rights in rem. Secondly, when the cause of an action and the subject matter of dispute affects the third party rights, have ego omnis effect. Ego omnis, which is a Latin word meaning towards all or towards everyone. Your Lordship, the disparity between the amount of the cargo lost at sea and that delivered brings about the subordinate right in personam, as the owner of the ship can be sued for fraud and or theft. Your Lordship, whether the question of whether or not there was fraud and theft arises, an action in rem in this case cannot be non-arbitrable. In the case of AFCON Infrastructure Limited versus the Cherian Vaki Construction Co., it stipulated clearly that an action in rem where there is a question of fraud and theft cannot be non-arbitrable. Your Lordship, the letter of subrogation obtained ultimately gives the insurance company the right as a third party to collect debt, thus bringing the fall that the principle in the earlier case mentioned by my leading counsel, the Vidiadrolia case, where the court established that the non-arbitrability of the right in rem include matters involving third parties and non-signatories to arbitration agreements. Your Lordship, the Supreme Court decision in the case of Vima Kishore Shah and others versus Jayesh Dinesh Shah and others, it sheds more light on the situation at hand. Your Lordship, I will seek Your Lordship to briefly explain a fact in this case, Your Lordship. Your Lordship, the issue of arbitrability arose in the context of a dispute intercede amongst the beneficiaries of a deed of trust. Your Lordship, the counterparties opposed the invocation on the ground that the beneficiaries were not parties or signatories to the trust deed, and accordingly, the arbitration clause in the deed cannot bind them. Your Lordship, the Supreme Court agreed and found that the disputes between the beneficiaries of a trust are non-arbitrable. The decision was based on two reasons, which are very important for this case, Your Lordship. Firstly, the court found that the arbitration clause contained in the trust deed does not satisfy the requirement of Section 2B and Section 2H and 7 of the Arbitration Act of India, mainly because the beneficiaries are neither parties nor signatories to the trust deed, Your Lordship. Secondly, the court found that grievances involving the rights, the duties, and obligations of the settlor, the trustees, and the beneficiary are specifically governed by the provisions of the Trust Act, which can be found in Section 17, Section 11, Section 34, Section 36, 41, and 74 of the Trust Act, Your Lordship. Your Lordship, and a very important case in this in this argument is the case of the JS Ocean Liner versus the MV Golden Progress.
Sorry,
which was recorded in 2000.
sorry. The erstwhile case you referred, does that case has any relevance to this case? The
The
present
JS
case?
Ocean Liner.
Yes, the
Yes, it-
trust case.
What case, Your
The
Lordship?
trust case that you mentioned now,
Yes, Your Lordship. It has a relation.
where was it an action in rem or was there property involved in that?
Okay, Your Lordship. The importance of the case here is it explains the action in rem, bringing the action in rem and explain its context in a dispute intersect among the beneficiaries, which makes us bring an example of a deed or of a deed of trust, Your Lordship.
Was it an action in personam?
Your Lordship,
Don't you think that was an issue between private parties? Right, private
yes,
rights.
that was an issue as an action in personam, Your Lordship. So
Yes.
I'm bringing the example of an action in personam where it is arbitrable and where it is non-arbitrable, Your Lordship. In my continued argument, I will list the rest for Your Lordship. Permit me, Your Lordship.
Counsel, just a moment before you proceed. Are you trying to say, okay, help us understand how you have a right in rem here? What is your right in rem? Because we are convinced that you have a right in personam in this particular matter. Convince us
Yes.
that you have a right in rem before you establish that a right in rem is the only thing that can be arbitrable.
Yes, Your Lordship. Like I mentioned earlier, an action in rem are prevalent in the sphere of admiralty law. Like an action in rem is a
Counsel,
is a
one second.
action.
Your
Yes, Your
entire
Lordship.
voyage began because you have an agreement, a contract with the owner of the ship. This is the charter agreement, right? You're a charter party. You
Yes,
chartered the ship so that you can convey certain goods from point A to point B. This is a contract. Contracts are essentially bipartite or tripartite. And depending on the number of parties, you have an agreement between them. Ultimately, what happens is you have a right in personam. Each party to the contract has a right in personam. Convince
Your
us that you have a right in rem. If it is a right in personam, it is arbitrable. Right in rem is not arbitrable. So you convince us how this is a right in rem, because we are convinced here that there is only a right in personam.
Your Lordship. Your Lordship. The right in rem, yeah, it's a right against, it's an action against the world. Your Lordship, there was fraud and theft. There was an instance of fraud and theft in this particular case. So an action in rem cannot be non-arbitrable, Your Lordship. However, I would still love to pass it to my leading counsel for
Your
more.
time is over, I think.
Your time is over, counsel. Please complete your argument. Conclude your argument. Speak or two.
Thank you, Your Lordship. Your Lordship, in the light of the facts stated, the issues raised, the authority cited, and the argument advanced, it is most humbly prayed and implored before this honorable court that it may be graciously pleased to declare that the court holds that it has the jurisdiction to hear the case and declare the arbitration agreement invalid. Also, the court declare the general average unsustainable due to the vessel not being seaworthy. The court should find the respondent guilty of fraud as a result of the short delivery of cargo of methanol. The court should mandate the respondent to pay for any expenses incurred by the claimant in the course of the case. And also, most importantly, the court should hold that an action in rem is not arbitrable under the Arbitration Act. Conclusively, my lord, your lordship, for all the reasons put forth today, the petitioner requests that this honorable court uphold the prayers of the petitioner. I'll end with the case of Metropolitan Properties Limited versus Lannon, where Lord Denning held that justice must be rooted in confidence, and that confidence is destroyed when the right-minded man thinks and leaves the court thinking that the judge was biased. Subject to any further questions, your lordship, these are our submissions. Most grateful, your lordship.
Yes, petitioner side.
Team
You can
team
continue.
119,
Yes.
the permission of the Lordship. Team 119, speaker 1, you have 20 minutes. Speaker 2, you have also 20 minutes and you have 5 minutes for the rebuttal. Speaker 1, you may start.
May I please sound record? Myself and my co-counsel are here to represent the respondents in the case of Octa Limited versus owners and parties interested in MV Moonlight. If your lordships are knowledgeable on the facts of the case, counsel seeks permission to move on to the issues.
Yes, please.
Much obliged, Lordship. So, Your Lordship, the first issue for our case is in view of the arbitration clause in the charter party, whether the excess of admiralty jurisdiction by the court is valid or not. The second issue is the declaration of general average legally sustainable if the vessel is unseaworthy. The third issue is whether the court considering the issue is bound by sanctions imposed by a third country. Fourth is, since the claim for short delivery of cargo is raised before a court, where a counterclaim is also raised by the owners, demanding GA contribution, whether the court can adjudicate on the rival claims, considering the fact that alleged damage occurred within territorial waters. And lastly, does the provisions of the Arbitration Act exclude an action in rem from its purview as non-arbitral? Myself, Counsel 1 will be dealing with issues 1 and 2, while my co-counsel will be dealing with issues 3, 4, and 5. If your lordships are satisfied with issues, my counsel seeks permission to move to the arguments.
Yes, please.
Much obliged, Lordship. So for the first issue, Your Lordship, it is humbly submitted that the excess of admiralty jurisdiction by the court is not valid. The charter party involves the arbitration clause, which is for resolving all disputes between the claimants and the owners. Your Lordship, according to the Arbitration Constitution Act of 1996, an arbitration clause which forms part of a contract shall be treated as an agreement independent of other terms of the contract. The arbitration clause in this contract was that in case of a dispute between both of the parties, the arbitration shall be conducted in London. In the case of Roger Shashaw versus Mukesh Sharma, it is seen to show that the court's approach to interpreting the arbitration agreements, particularly regarding the parties' implied choice of seat. So the court found that in this case, the court found that the designation of London as the venue of the arbitration in the absence of any express designation of a seat would suggest that the parties agreed that London would be the seat of arbitration. Furthermore, the case of Harman Innovation Shipping Limited versus Gupta Coal India Limited, the test of presumed intention was applied, and it is held that London will be the seat of law. The court came to such conclusion by stating that the parties intended to make London as the seat of law, and for this, there is ample indication through various phrases used in the arbitration clause, like arbitration in London to apply, arbitrators are to be members of the London Arbitration Association, and the contract to be governed and construed according to English law. Furthermore, Your Lordship, in the Supreme Court, in the case of Aitson Bulk versus Ashapura Minakam, the Supreme Court held that since the arbitration clause stipulates that the dispute shall be settled in London and English law would apply to the arbitration, the intention of the parties is manifestly clear to exclude the applicable part of 1996 Act and thus conclude and the conduct of the arbitration as well as any objections related thereto, including the award, shall be governed by English law. Your Lordship, in our case, it is clearly stated that in case of any disputes between the parties, the dispute resolution will be through arbitration in London. York and Court states that York and Court states that any dispute regarding general average has to be settled in arbitration in London itself. Some of the claims by the claimants, such as short delivery of cargo and GA contribution, can even be accessed in arbitration in London, as it has the power to resolve the disputes between the two parties. Your Lordship, the second part of my first issue will be dealing with admiralty jurisdiction. So UNC clause, which was formed to ensure freedom of ships to move safely from one country to another, has clearly stated that the territorial sea is a belt of coastal waters, and the territorial jurisdiction encompasses territorial waters up to 12 nautical miles from the closest base endpoint of the sea. Only if incident happens in the territorial waters of the country would have clear jurisdiction for taking the case up for arbitration in that country itself. This is also one of the arguments raised by the defendants in Laxo versus Union of India. The claimants had stated that this particular case had no relevance to ours, stating that it was a criminal case, but the respondent counsel would like to state that we are only taking this as like as a reference, as the Italy challenged the Kerala High Court's arrest of their ship and their crew, alleging that India has no jurisdiction to try the case at the very instance as it did not happen to be in the territorial waters of India. So coming back to our case itself, Your Lordship, owing to the vagueness in the facts as to the ship's location when it had jettisoned the cargo for fear of being capsized, There is nothing that points to it being in India's territorial waters at the time of the cargo being jettisoned. This would make the excess of admiralty jurisdiction by the court invalid. If the lordships are satisfied with the first issue, Constitution seeks motion to move to the second issue.
What about the Section 9 of Arbitration Act?
Your Lordship, can you repeat your question?
So Section 9 of the Arbitration Act, don't you think we have jurisdiction under Section 9 of the Arbitration Act?
Your Lordship,
Are you aware of what Section 9 is, Counsel?
yeah, Your Lordship. Section 9 talks about interim order, right, Your Lordship?
Yes.
Please answer the question that was asked.
It can only pass interim orders, Your Lordship. That is the what is stated in Section 9. And
Interim orders only.
Yeah.
So this case will not come under Section 9. That's your submission.
yes, Your Lordship.
Okay.
Counsel, one question before we continue. Can a subject matter that is covered under a special statute, can you bring that under arbitration?
Can you elaborate, Your Lordship?
You have a special statute here, the Admiralty Act.
Yeah, Your Lordship. Yes.
It covers a specific area. It's a specific subject matter that is covered by the statute. Can you bring that under the Arbitration Act, the Arbitration Conciliation Act of 1996?
Counsel does not know the answer to that, Your Lordship.
Let's put it in a general way. Let's forget about the Admiralties Act. I'm putting you a general question. When a subject matter is covered by a specific statute, let's go consumer protection. Will that subject matter be arbitrable?
I mean, Your Lordship, arbitration is mainly there so that it can resolve the issue between the parties, like before it actually goes to the court. So, counsel would like to state that yes, it would be able to arbitrate that.
Do you have an authority for that?
Counsel is not aware of that. Your Lordship.
Okay, proceed.
Moving on to the second issue, Your Lordship. The counsel for the respondent would like to state that the ship was seaworthy from the commencement of the voyage. In Gulandris Brothers Limited versus Goldman and Sons Limited, it was said that where the GA Act was brought upon by the ship owner's action before, the ship owner's claim against the cargo interest for the contribution of GA failed. It can be therefore inferred that if a ship wasn't unseaworthy from the commencement of the voyage, and if the owners exercised due diligence to make the ship unseaworthy, the claim for general average can be sustained. In the present case, Your Lordship, a clean fixture was confirmed between the cargo owners and the ship owner on 19 May 2021 through brokers Green and Black Middle East. Claim fixture is acceptance of the charter party agreement between the ship owner and cargo owner. This is done only after the inspection of documents, including the certificate of seaworthiness. Therefore, it implies that the ship was seaworthy at the time of commencement of the voyage, and the ship owners had taken due diligence to make the ship seaworthy before the voyage. Therefore, the ship owners can claim general average contribution from the petitions. In the present case, Your Lordship, the ship experienced bad weather, which actually can be considered as an act of God, as it is clearly stated in the facts that the crew, that the ship had listed 35 degrees to starboard side, which shows that the crew actually tried to fight the storm. The petition side has stated that it is a regular occurrence, but a storm that is so severe that even though a ship that is shown to be already seaworthy had tried their best to fight it off, and even then it almost capsized. So that would show that the storm was so severe that it actually can be classified as more or less a natural disaster. So that is the reason why the cargo was jettisoned, so that the entire ship would not be capsized, giving rise to an extraordinary sacrifice for the benefit of the common maritime adventure. According to Rule A of York and Dover course, the said event can give rise to GA. Your Lordship, furthermore, in the case of Alice versus Alliance Elementor, it was held that a defective passage plan can make a ship unseaworthy. In the present case, according to clause 35 of the NYPA form, the charterer should not make the ship go through unsafe ports. BIK Leran was an unsafe port due to political unrest. And according to clause 35D, if the vessel proceeds or through the area exposed to water, the charterer shall reimburse to the owners any additional premiums required by the owner's insurers and cost of any additional insurance that the owner reasonably requires in connection with the waters. As is clear from the facts, Your Lordship, the ship owner had made the ship go through that particular port only at the insistence of the petitioners, Your Lordship. Therefore, the petitioner is liable to indemnify the ship owner in that case. So to conclude, Your Lordship, Council would like to state that would like to humbly submit that the claim for general liability is sustainable as the ship was seaworthy before the commencement of the voyage, and the ship owner has exercised due diligence to make the ship seaworthy. Also, the ship owners are entitled to be indemnified due to the violation of the waters caused by the cargo owners. The first council has finished this issue. The rest of the issues will be handled by my co-counsel.
Counsel, just a moment. You're talking about unsafe ports. Are you trying to argue that because you went to an unsafe port, the ship suffered any damage?
It is we are trying to, we're not like legitimately saying that it is the reason, but we are also implying that it could be the reason, Your Lordship.
Are you producing hypotheticals before this court counsel?
No, Your Lordship. It's like it can be inferred from that, Your Lordship. We're not going into like hypothetical. It's like a logical assumption.
Why exactly was this port unsafe?
Because of political unrest, Your Lordship.
Exactly. Can political unrest make a ship unsafe? If you're talking about a situation of war, let me complete. If you're talking about a situation of war, if you say that there are, let's say, mines in the seabed, if you say there are anchors or any other, let's say, a very shallow seabed, things like that, which can actually physically damage the ship, I can understand your argument. Political unrest in the country will be good enough to declare a political situation as unsafe. I can understand that. How exactly does it affect the physical condition?
Your Lordship, okay, Your Lordship, as per the facts of the case, Your Lordship, the military had actually taken over all the ports in Laran. So that would like, and it's obvious that once the military has actually taken over a particular place, they would set up defenses. So it could be assumed that obviously the military would have put up mines or any defensive instruments so that the port would not fall out of their hands, Your Lordship.
Granted, if that is the case, as the owner of the ship, were you not responsible to ensure that the seaworthiness at the time of departure from that port also?
Your Lordship, Your Lordship, the damage would have been like very minor, that like so minor that it could have slipped the eyes of everyone over there, Your Lordship. But like maybe as the ship actually
are you submitting that there was negligence on your part?
No, Your Lordship, no.
Then,
Your Lordship, like even if like the damage would have been so minuscule that like the ship owner would not have been eligible for that particular.
Who has the burden of proof in the case of Seaworthiness Council?
The burden of proof, Your Lordship, it rests on the. It rests with us, Your Lordship. We have to prove that. Yeah.
Forget about how minuscule it is. There is an implied warranty upon you to ensure seaworthiness of the ship. If it's not seaworthy, you are liable. So by your own submissions, you have now given us the conclusion that the ship was unseaworthy when you departed from that port.
Your Lordship, the council would like to state that first of all, it was seaworthy at the commencement of the journey. Secondly, the only reason why the council actually went through that particular port was because the cargo owner insisted on that, Your Lordship. So the council would like to state that the responsibility for that instance happening rests not with us, but with the cargo owners, Your Lordship. Because they are the one that
actually have accepted the terms, once you have agreed to go by that particular path, you have agreed for that maritime voyage. But I understand there's a condition for safe ports only, but then you have acquiesced to it. You have gone by that. You have accepted the condition. You have gone to the unsafe port. Once you depart from that, at the instance of whom is irrelevant. You have accepted it. You have acquiesced to it. If you suffer damage specifically because of the unsafe port, I accept. You have not produced any evidence to show that. There aren't enough arguments to show us that you have suffered damage because of the unsafe port. More importantly, you have kept harping on the fact that there was an act of God. the violence or the torrential conditions of the sea.
Yes, Your Lordship.
Under such circumstances, you would be liable, counsel. The ship has a contributory, at least a contributory role to play, the owner of the ship. Do you have anything else to convince us that you are not liable, that the entire thing is an act of God completely beyond your control?
Your Lordship, as I stated earlier, Your Lordship, as is evident from the facts, it has stated that the ship listed 35 degrees to the starboard side, which again, as I stated earlier, Your Lordship, would show that the ship crew, like the ship did not suffer that particular issue, like just willy-nilly, Your Lordship. The crew did try to fight off the storm, Your Lordship, but like
with an unseaworthy ship.
It was not unseaworthy, Your Lordship. Like
at the time of departure from your point of collection, you have not convinced us that it was seaworthy now.
Your Lordship, again, the council would like to state that that particular like there was no particular damage that was visible, Your Lordship. The owner had also made sure that it was seaworthy at the beginning and took all necessary precautions to make sure that it was. And even in the
yes,
and even after it went to the second port, Your Lordship, there was no visible damage. The facts does not point to any visible damage or any damage that could have hindered the journey of the ship in any normal course, Your Lordship.
Yes, okay.
But the and that's why we are stating that it's an act of God, because even though there was nothing that could have hindered the ship, there was nothing wrong with the ship that could have actually hindered its journey. The storm was so severe that it had actually required the crew to jettison the cargo from the ship, for fear of it actually capsizing. Because the storm was that.
Please conclude.
Okay, Lordship. It is so, Your Lordship, it is humbly prayed that the claim for general liability is sustainable, as the ship was seaworthy before the commencement of the voyage, and that the shipowner had excess due diligence to make the ship seaworthy, Your Lordship. So that ends my issues. My co-counsel will be dealing with the rest of the issue. Thank you.
Yes.
Yes.
May I please honorable myself to be dealing with third, fourth, and fifth issues. The council seeks to move to the third issue.
Okay. Go ahead.
Much obliged, Your Lordship. Okay. The third issue is the sanctions imposed by the court, considering the issue is bounded by sanctions imposed by a third country. So, as the charter parties entered the NYPE form, it's obliged to obey it. As per clause 54 of NYPE form, the charter party can decide all disputes on English law, and it will be referred to England in accordance with Arbitration Act 1996. At the same time, any disputes arise regarding the general average should be arbitrated in London as per York and Work Codes. Section 13 of Code of Civil Procedure states the principle of res judicata in foreign elements. It clearly says that the judgment or sanctions imposed by a foreign court can be executed and enforced in India. As per the wordings of Section 13, a foreign judgment shall be conclusive as to any matter directly adjudicated upon between same parties or between parties under whom or any of them claim to be litigated under the same title. In reference to Vijilal Ramjidas.
Council, just a moment. Are you relying on Section 13(1)(3) of CPC?
Yes, Your Lordship.
Please explain to me why that is relevant here.
This CPC deals with the civil case. So
I understand CPC deals with the civil procedure code and civil cases. Please tell me why Section 13 is relevant here. Section 13 talks about implementation and application of foreign judgments. What foreign judgment are you relying on?
So I'm coming to the point, my lord, Your Lordship. In Brijilal Ramjidas versus Govindas case, the Section 13 of Code of Civil Procedure speaks not only of judgment, but any other matter directly adjudicated upon. So all sanctions, including judgment, should be considered there. And hence, the sanctions imposed by a third country that's London, will be awarded to Admiralty Court of India as per the previous section.
Are you saying by default
your
any
lordship is-
judgment or order of a foreign court is implemented in India? By default, you bring it and it automatically applies in India. You have an order from a British court, you have an order from an American court, you bring it to India and you immediately it happens. How does Section 13 work? It does not work by default, counsel. Give me an answer.
Can you,
Okay.
sorry, can you please enlighten us with this issue, this third issue? What actually is that issue?
Whether the Admiralty Court is the sanctions imposed by a third country, that's maybe London, can be imposed in the Admiralty Court in India. So that's basically the third issue. Third issues, and Section 13 of CPC deals the foreign. Principle of res judicata in foreign elements. So any sanctions imposed by a foreign court can be excluded.
Is there an arbitral award in this case? Have you gone to arbitration? I mean, did the claimant go to arbitration?
No, Your Lordship.
Then which is the arbitral award you are referring here?
Counsel, what are you trying to implement here? Have you understood the issue, counsel?
The issue is a bit vague, but I try to understand it in to the maximum level. So what I believe is Section 30 of CPC, the res judicata of foreign elements. So
Okay, then
okay.
please present your points.
Can I move to the next sub-issue, or should I stick on to this?
Do you have anything further to add in this sub-issue?
No.
Then please proceed.
Okay. So the second sub-issue is imposition of sanctions by third country. The sanctions imposed by countries on other countries or regions are prescribed under Chapter 2 of Foreign Trade Policy. The key sanctions inside it was direct and indirect export from Iran or to Iran for certain items are restricted. As the bunkering of cargo was at BIK port Iran, and the military has taken over the control of ports under the limits of Iran, and there is a political unrest going on there. The Chapter 2 of FTP, as per the Chapter 2 of FTP, the imported cargo from Iran would be illegal. So it's humbly prayed before the Honorable Court of Indo to consider the sanctions imposed by a third country. If Your Lordship is satisfied with the third issue, Council seeks permission to move to the fourth issue.
We are not satisfied, but please go ahead.
I concur. Continue.
Thank you. So the fourth issue. According to Section 8 of Arbitration and Conciliation Act, the court has the power to refer a case to arbitration if there is an arbitration clause in the agreement, and if the court finds that the arbitration clause is valid. The Supreme Court in Harmony Innovation Shipping Limited versus Gupta Coal India Limited applied the test of presumed intention and held that London will be the seafloor, as it was said so in the agreement. Roger Shasha versus Mughal Sharma sheds further light on the court's approach to interpreting arbitration agreements, particularly regarding the parties' implied choice of seats. The court found that the designation of London as the venue of the arbitration in the absence of any express designation of seat would suggest that the parties agreed that London would be a seat of arbitration. In the present case, a claim for general average is raised by the respondent. According to York and Verb rule and clause 54 of NYP form, any dispute regarding general average is to be settled through arbitration, and the venue selected for the same given in clause 54 is Lloyd's, London. If your lordship is satisfied with the fourth issue, the council seek permission to move to the fifth issue.
Yes.
Council, just a moment, Council. Please confirm for me why you've relied on Section 8 of the Arbitration Act. Under Section 8 of the Arbitration
Section
Act,
8 of the arbitration.
can a court say that the
Section 8
London,
of
just 1 second, can a court in India say that the arbitral forum in London should take cognizance of some matter? That the matter should be arbitrated by a tribunal in London? What was the point of Section 8? Why did you bring in Section 8?
Section 8.
Yes. You started your argument with Section 8.
It provides that judicial authority shall, on basis of agreement between two parties, direct the parties to go for an arbitration.
I accept that. And then you went to York Antwerp rules and you said that the arbitration has to happen in London. Please correlate these two arguments.
Yes, because there's a valid agreement was put forward by the parties before that. In the proposition, the case is proposition itself, it was clearly defined that any disputes relating to general average or anything should be settled in London.
Okay. Council, is there a difference between seat of arbitration and venue of arbitration?
Seat of arbitration.
What is the governing law? What is the
venue
governing
or
law in this particular case? Governing law.
Lloyd's.
Lloyd's.
No. Governing law.
Where is the seat of arbitration? What will be the governing law?
London.
Answer these two questions and I'm done.
English law.
Governing law.
As it's.
Okay. Proceed, Council.
Okay.
Proceed.
So the council moved to the fifth issue. Council humbly submit before this honorable court that the provisions of the Arbitration Act does not exclude an action in rem from its purview as non-arbitral. In the case of Vidya, Roya and others versus Durga Trading Corporation, the Supreme Court held that the disputes are not arbitrable when the course of action or the subject matter of the dispute relates to action in rem that do not pertain to subordinate rights in personam that arise on the right in rem. Supreme Court's decision in Booz Allen and Vimal Kishore Shah and others versus Jayesh Dinesh Shah and others, the Supreme Court was faced with a question as to whether an action for the enforcement of a mortgage is arbitrable in India. The court answered this question in a negative way, but while doing so, it clarified in general terms that the following two broad classes of disputes are incapable of being resolved in arbitration. First, matters that are reserved by the lawmakers to be determined exclusively by the public. Second, matters by which stand excluded from the purview of private law. Within the second category, actions for enforcement of rights in rem, which the court held are unsuited for arbitration and can only be adjudicated by courts or public tribunals. A right in rem, as the court explained, is the right exercised against the world at large. In contrast, a right in personam is one exercisable against a specific individual. The court concluded that traditionally all disputes relating to rights in personam are considered to be amenable to arbitration, and all disputes relating to rights in rem are required to be adjudicated by courts and public tribunals. The court did clarify this, that this is not an inflexible rule, and subordinate rights in personam arising from rights in rem have always been considered as arbitrable. Furthermore, in JS Ocean Liner versus MV Golden, it was decided by Bombay High Court, and it differentiated the action in rem and action in personam. That's whether the nature of an arbitration application under arbitration act is distinct from an arbitration action for a arrest of a vessel. In this case, the court stated that the right to arrest the ship is the right in rem, where the application filed against the individual under arbitration law is right in personam. Thus, the Indian courts can arrest the ship despite the fact that there exists an agreement for foreign seated arbitration between the parties. So in the particular case, in the current case, as it is evident from the facts that owing to the fact that the need to jettison the cargo arose as a result of a chaotic weather condition to an unfavorable weather condition, which is essentially an act of God, the ship owner will not come under any fault because it's an act of God and will not be liable for the same. Hence, this is an action in rem rather than the action in person. Hence, it's humbly submitted before the Honorable Court of India that the provisions of Arbitration Act doesn't exclude the action in rem from its purview as non-arbitrable. If your lordship is satisfied with the issue, the council would like to move to the prior session.
Counsel, can you repeat the last line which you just stated? Are you
the
saying-
current case?
Huh. Please repeat.
Okay.
Please repeat.
Just in the current case, as it is evident from the proposition, as it is evident from the fact that the need to jettison the cargo arose as a result of a weather condition, an unfavorable weather condition, which is essentially an act of God. The ship owner will not come under any fault and will not have any liability. Hence, this is an action in personam, and there is no problem. It's no problem for going for arbitration.
Okay, counsel.
Is
I don't
between two
understand.
persons.
I understand,
between-
but why is jettisoning and all of that relevant? How is that relevant for a right in personam? Act of God,
Because,
jettisoning of goods. Why is all of that relevant?
mm,
What is your right in personam?
it's
Where is the right in personam
between,
coming?
between two individuals.
Who are the individuals here? How did you create that right here?
The claimant and the ship owner ship company can be considered as the two.
How exactly did that right arise? A right in personam has to arise, no? It has to be created somehow. How did that right be created?
Because it's regarding the general average claiming.
By claiming general average, you create a right in personam.
Because
Why are you claiming a
it's-
general average
It's
constant?
as a result of, because it's a contract between the two parties, your lordship. It's between.
Accepted.
Yes.
Okay.
So
all contracts are rights in personam.
not exactly. Because it's in right in personam, in literally means it's between two parties, not against all world. So
Content.
in a contract there will be two parties, and obviously if a breach of contract arises or something arises, then it will affect the two individuals only. The case of affecting others will be much less, or it can be considered.
So all contracts are rights in personam.
Yes, it's
Okay, last question. Are you stating that there is a right in personam because of the contract or because of the claim for general average? Clarify that point for us.
Pardon, your lordship, can you explain it once more?
The right in personam you are talking about, did it arise out of the contract or your claim for the general average?
We are trying to say that since the ship owner is not liable, it cannot be considered as a person. So it can be considered as a person.
Okay, let me put the same question I asked your teammate. If a special statute governs the field, is that subject matter arbitrable?
Yes.
Do you have any
Yes.
authority on that point? Just don't give me a yes. Give me authority. Simple yes will not suffice, counsel. Special statute versus arbitration. Is it possible? If there is a special statute, Admiralties Act is telling you that there is a specific court which is conferred jurisdiction on such subject matters, and then you have the Arbitration Act which tells you that if there is an arbitration clause, you refer the matter to arbitration. When there are two statutes giving you diametrically opposite solutions or diametrically opposite forums, how is there harmonization? Is there any authority which tells you which you can rely on?
As per the contract, any kind of dispute should be settled in London, but Admiralty Act of 2017 will it can I don't think we don't think that it can supersede, because
I need authority,
there's
counsel. You can't make a statute against, sorry, you can't make a contract against the statute. If there is a clause in your contract that is against the statute, it does not apply. We'll either sever it or we'll treat the entire contract as void. You have two statutes. If you rely on
Yes.
one, you have a valid argument. But if it goes to the other, your argument goes out. So convince us of why your argument is correct. Why Arbitration Act is the one that you have to rely on. Convince us.
it's not clear that where the jettison take place. It's just we
Forget
are
about
only aware.
territorial jurisdiction, council. Forget about the territories. Forget about your exclusive economic zone and all of that. I'm telling you, there are two statutes. Which do we rely on? Because if Admiralties Act is what we rely on, obviously we entertain jurisdiction. You started off by saying we don't have jurisdiction. Then all your arguments based on arbitrability are irrelevant to us. Because if we take jurisdiction, arbitration is out the window. It does not concern us anymore. Do you have any authority on that point?
Is there any provision under under any of these acts which gives prevalence over the other?
Any case law, any
Yes, yes, yes.
principle, anything you can rely on. Let's not search at this instance, counsel.
Yeah. The council pardon for the kind of clerical errors might be.
Okay,
Yeah.
one final question. So your submission was action in rem is arbitrable, right?
Yeah. Yes.
So does an arbitral tribunal can give an award to arrest a ship?
Arbitral. No.
Please answer, counsel.
Yeah.
Yes or no?
No.
No. Okay.
No. Yes. No.
Okay. You can move on to your prayers.
Oh, thank you, Your Lordship. So therefore, in the light of facts stated, issues raised, arguments advanced, and the authorities cited, it is most humbly prayed and implored before this honorable court that it may graciously please to adjudge and declare that, firstly, the exercise of admiralty jurisdiction is not valid and reasonable. Secondly, the declaration of general privilege is legally sustainable and it should be maintainable. Thirdly, the sanctions imposed by a third country are bound by the court and it should be delivered. Fourthly, the court cannot adjudicate the claims by considering the damage occurred within the territorial waters and it should be challenged. And finally, the Arbitration Act doesn't exclude action in rem as not arbitrable and it should not be quashed. Also pass any other order that it may deem fit in the light of equality, justice, and good conscience. And for this act of kindness, the Council of Respondents shall be duty bound for our prayer.
Yes, counsel. Thank you.
119, if the Lordships are ready, the team 109 may start your rebuttal.
Yes.
As a team 109 have exhausted their speaking time, with the permission of the court, they might get.
Yes. 5 minutes can begin.
Team 109 you have 5 minutes extra time.
May it please this honorable court once again. I am Amuda Kolawole Ibrahim. Yes, Your Lordship, the respondents has argued beautifully, and particularly to the third issue. I want to talk about paragraph 3.1.4 of page 16, where he cited section 13 of the Code of Civil Procedure. Your Lordship, in this instant case, the Code of Civil Procedure does not stand, Your Lordship. And this is because there are 6 tests to the code of section 13 of the Code of Civil Procedure, Your Lordship. And one of the first test is that the code of the section 13 shall be rendered inconclusive if it has not been pronounced by a court of competent jurisdiction, Your Lordship. In this instance case, an arbitrary tribunal has not even been set, Your Lordship. So the provisions of section 13, that is if we are agreeing that an arbitrary tribunal can be equated to be an arbitral court, an admiralty court, Your Lordship. In this case, section 13, Your Lordship, does not apply, Your Lordship. Also, Your Lordship, to the question raised about jettisoning of goods that Your Lordship asked earlier, Your Lordship, the Merchant Shipping Act of 1958 deals with jettisoning of cargo, Your Lordship, and section 430 of this said act provides that if the owner of a shipping vessel experiences jettisoning of cargo, he has to approach the proper officer at such port. That means when they got to the west coast of Indo, they met with the officer and said 500 to 600 was missing, Your Lordship. And after a survey was taken, it was 650 that was found. This further reaffirms our claim that there is an issue of fraud there, Your Lordship. The counsel humbly submits.
Your Lordship, in page 19 of the respondent, they mentioned that in the case of JS Ocean Liner, that the Indian court can arrest the ship despite the fact that there exists an agreement for foreign seated arbitration between the parties. Your Lordship, in rebuttal to that, I say the court in the case of JS Ocean Liner, it held that section 9 application, it's under the Arbitration Act, is an action in personam, where the proceedings are initiated against a particular person. Thus, a section 9 application seeking interim relief for arrest of the ship as security for an arbitration would not be maintainable. Your Lordship, as regards the question you asked me earlier about the action in rem, Your Lordship, a recorded case is the case of Maya HK Limited Care. It's a recorded case where the jurisdiction of the court is plenary and unlimited. Thank you very much, Your Lordship.
Yes.
Yes, counsel. Thank you. Court officer.
Is there a survey button?
Lordship, team 119 can present their rebuttal. They also have 5 minutes.
Team 119.
Your Lordship, respondent counsel would like to forego the rebuttal.
Okay.
With the permission of the court, let me inform it is time for the tabulation. So the teams may please leave the court for further inspection and the team managers may please remain.
The
Teams
teams
can
can
leave.
leave.
Teams, please leave. You can rejoin when your managers let you know. Please leave, teams.
Team 109, please.